Now, did Chief Justice John Roberts vote to uphold the Affordable Care Act because he was feeling pressure from the White House, veiled threats from President Obama? CBS has a report out suggesting he changed his vote at the last minute because of that kind of pressure. Or did he author that opinion in some kind of Machiavellian attempt to limit the impact and scope of the Commerce Clause and thus ultimately limit the ability of the federal government to grow its powers while upholding the mandate? We don't know, but I think it's pretty safe right now to say he should belong in the swing vote category. But that being said, even if the court looks like this, 3-2-4, this is still the most conservative court the United States has seen over the last 20 years. This is the most conservative court in maybe ever. Let me just throw up a couple cases to show you what this court, often under Chief Justice John Roberts, has upheld, has ruled on. First of all, last year in Chamber of Commerce versus Whiting, this was an immigration case that dealt with the concept of federalism. The court sat on the side of limiting the federal government, empowering the concept of federalism. And of course, everyone understands and remembers Citizens United case, which is basically a First Amendment case. We have others such as the District of Columbia versus Heller, which is a Second Amendment case, gun rights case, and Zellman versus Simmons-Harris. This is a school choice case. These are all issues important to conservatives, that this court, with some different justices at times, this court has ruled in what conservatives would see a favorable light. Now, that brings us to where is this court headed in the future? So for that, let's turn to a question from one of our viewers on Twitter. This is a question from Clay Rank. He said, did Roberts rule the way he did to create breathing room for 5-4 decisions that are upcoming on affirmative action and the Section 5 Voting Rights Act cases? So let's do this. Let's talk about what cases are coming before the Supreme Court, possibly in the next term. We'll put that up right now. We know that in the next year, the Supreme Court has agreed to hear Fisher versus the University of Texas. This is an affirmative action case. This is going to decide whether or not it's constitutional to continue to provide racial quotas to alleviate past racial injustices. Affirmative action. But not only that, we have Proposition 8 that has been appealed to the Supreme Court. This is the gay marriage case out of California, and the Supreme Court has not yet agreed to hear it, but it's been appealed to the Supreme Court that they could rule on this as well. And of course, Texas versus Eric Holder, this is the voting rights case. This is talking about voter fraud versus the concept of voter suppression. All of these cases are coming up before the Supreme Court very soon. So last, I'm going to come to you guys with this discussion now, and we'll start with a question, another question from Twitter, and this is from Oregon MJW, and she asks, can the Supreme Court be saved as neutral arbiters in the best interest of the entire population? She hopes so. Of course, the presumption there is that it is not. What do you guys think?
Well, if you think that neutrality means looking at the Constitution for what it says, not what we hope it to say, then we'll see, Will, because you talked about protecting the court for 5-4 decisions. Well, I don't really understand the logic behind that, because there's been a lot of 5-4 decisions. In fact, most of the really important cases in recent years have come down along a very close line. And so I just don't think that there's any the conservatives are really desperate to find something in John Roberts' decision here that's redeeming. I know we've disagreed about this a little bit. I think there's almost nothing redeeming about the decision because we've already established limits to the Commerce Clause in previous cases. This just basically said the Commerce Clause can't do literally anything that the federal government wants it to. That's not something that we should be celebrating. And the idea that the judges should even be considering what the outside opinion of these cases are, that undermines the entire process. Because the fact that we have a legislature, we have people sticking their finger in the air, wondering which way is the wind blowing on this. I'm going to go that way. I want to get reelected. The Supreme Court is supposed to be there for life tenure because they're not supposed to care about that stuff.
That's right. And to answer this particular tweeter's question, that's not the role of the Supreme Court. The role of the Supreme Court is not to be a neutral arbiter to decide what's in the best interest of the population. That's just not the role of the Supreme Court. That's the role of the legislature. The role of the Supreme Court is simply to decide one thing. Is the law that's passed constitutional? Not is it good, not is it bad, is it constitutional?
And interestingly, Ann Coulter, well-known conservative columnist, I would say bomb thrower, she had a bit of an I told you so moment with Obamacare that she had written when John Roberts' nomination was under consideration, that because there wasn't this sort of wealth of information about his jurisprudence, it probably was going to turn out badly. and that it typically does for conservatives. When you don't know enough about this person's, judicial decision-making and the decisions that person has made, generally they end up the Kennedy, and now we're finding John Roberts, not the Scalias, Thomas, and Alitos. So my question on all of this, too, is just looking at the types of cases that the Supreme Court may be deciding. Stuart Taylor, he's written about this, he's mentioned it to me, a writer for National Journal, that the Supreme Court seems to be very focused and fixated on these social issues, affirmative action, Proposition 8, Voting Rights Act, when perhaps they should be looking more at economic issues to be deciding, and maybe deciding in the favor of economic freedom. And maybe the types of cases they're choosing can tell us a little bit about
are they turning down
our
cases that have come before them on economics?
He has said that it's tended to weigh on social issues, not so much on the economic ones.
I think one of the